You may all recall a little known woman in Massachusetts named Karen Reed. And yes, if you are a follower of this channel, you definitely know about Karen Reed. We covered every single day of that trial, especially the motions that were filed after the trial. And we did research on those specific laws that govern double jeopardy as it relates to Karen Reed's situation. We explained it all. We went through the appeal, we went through the motions, and I also told you basically what's most likely going to happen in this case. Nevertheless, that issue right now is in front of the Massachusetts Supreme Court. The briefing was already filed by Karen Reed's team. Now they're just waiting for the briefing by the state, and then they're going to set it for an oral argument, and then there's going to be an opinion issued by the Massachusetts Supreme Court with their decision. And for all the followers of this channel, you are most likely not going to be surprised by that decision. So, nevertheless, while that is all going on, the O'Keefe family was busy filing a civil lawsuit against Karen Reed. And they are alleging, number one, that Karen Reed is guilty of wrongful death. She caused the death of John O'Keefe by hitting him with her car. They're still buying that story, even though at this point there's no experts that the plaintiffs have to actually back that up. And the only experts that we've heard said that it's scientifically impossible for Karen Reed to have hit John O'Keefe with the car. The injuries and the damage to the car don't add up. Nevertheless, most likely the plaintiffs in that case, the O'Keefe family, the attorneys, are probably looking very hard for some real experts, not just an expert like Trooper Paul, but real biomechanical experts who will actually testify that not only is it possible, but it's probable that Karen Reed killed John O'Keefe by backing her car into him. That's what they're going to need in order to win that case in the civil arena. So we'll see if they actually are able to do that. Nevertheless, they did file that lawsuit, and they not only named Karen Reed, but they also named C.F. McCarthy's and the Waterfall. They named C.F. McCarthy's and the Waterfall because there is a cause of action called a dram shop. A dram shop is when a bar serves a visibly intoxicated person. If a bar serves a visibly intoxicated person and that person goes and causes damage to somebody else, well, under dram shop, the institution that served that person that alcohol could be liable as well. So they're suing C.F. McCarthy's and Waterfall, even though from the videos that we've seen, it didn't seem obvious that Karen Reed was visibly intoxicated. But they're still throwing them into the mix. It's always better to have more defendants in the case, so they're throwing them all in as well. So when a defendant gets served a lawsuit, so they have a few different options. Number one, they can ignore it, and then they're going to get defaulted, which is never a good idea. Number two, they can answer the complaint. And when you answer the complaint, so what you have to do is that the complaint is a list of paragraphs, 1, 2, 3, 4, 5, listing all of the allegations that you're making. The defendants have to answer each of those allegations. Number 1, 2, 3, 4. Do you admit or deny? Or they say we don't have enough knowledge to either admit or deny. So that's what you have to do if you want to answer the complaint. So that's what C.F. McCarthy's and the Waterfall did. They answered the complaint, either denying, admitting, or saying they don't have enough knowledge to either admit or deny each specific allegation. Well, Karen Reed's defense attorney did not actually answer the complaint just yet because he filed a motion. He filed a motion to stay the proceedings, meaning that he wants the civil case to just be paused until the criminal case wraps up in January. Right now, the retrial is scheduled for January. So he's asking the court, let's just pause everything and wait till the criminal case concludes in January, and then we'll pick it up where we left off with the civil case. And that's exactly what we're going to be jumping into today to see what the arguments to stay the case are and what are the arguments to not stay the case. So there's already been a motion filed by Karen Reed's defense team in that case, as well as a response by the O'Keefe family's attorney. And that's what we're going to be jumping into today. But before we do, I just want to make two quick announcements. Number one, I'm still kind of battling over COVID, trying to get better. I feel definitely a lot better, but still there's some nagging and I may have to take some drinks, and maybe you're going to hear the difference in my voice already. So I apologize for that. And I'm apologizing in advance in case I have to take a few breaks for some drinks. Number two is I want to give a shout out to the sponsor of this video. The sponsor of this video is the Suit Depot. There is a link in my description to the Suit Depot, and only for my listeners you get this special coupon. You're not going to find it anywhere else. It's only for our listeners, and that is that it's a 10% off coupon. You just have to put it into the coupon box, and the code is Brother Counsel, all lowercase, no spaces, just straight Brother Counsel for 10% off the Suit Depot. I get a lot of my stuff from the Suit Depot. Great store, good quality, very reasonable prices. Go check them out if you need to look your best. All right, now let's move on to the actual motion that is filed by Karen Reed to stay this case. So here we go. This is the memorandum of law in support of defendant's motion to stay. So what they did here, just for completeness sake, is they actually filed a motion, and then in that motion it was like a 2-pager, and then they said, check out our memorandum of law where we actually cite the basis, the authority, like we always talk about, the authority to support what we're asking for. So here we go. Legal standard. The decision to stay a civil action pending the outcome of criminal proceedings, which is exactly what they're asking here. They're asking, stay the civil action pending the outcome of criminal proceedings, is in the discretion of the presiding judge. So right away they're saying this is a discretionary matter. So judge, it is completely in your discretion what to do, which also means that it will only be reversed on appeal if there is a clear abuse of discretion. So if there's an abuse of discretion, then you can get appealed and reversed. Absent an abuse of discretion, it's not going to be reversed. And an abuse of discretion is usually very difficult to prove. Now, the next thing that they say here, which is very important, is that in considering a request for a stay, it would constitute a clear abuse of discretion for the judge to turn a deaf ear to a serious claim of privilege. So it is clearly an abuse of discretion if the judge turns a deaf ear, decides not to care about a serious claim of privilege. So right away, we have to think, does Karen Reed have any sort of claim of privilege, which would be a reason for the judge to be required to hear that claim of privilege and therefore grant the stay? Well, yes. Let's see what the privilege is. The privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is ongoing. So let's take a stop for a minute and talk about the Fifth Amendment. The Fifth Amendment, everybody understands, is the right to remain silent. You cannot be compelled or coerced to testify against yourself. Now, are you allowed to assert your Fifth Amendment rights only in a criminal case, or can you also assert your Fifth Amendment rights in a civil case? Are you allowed to do that? That's the first question. And the answer is yes, you are allowed to assert your Fifth Amendment rights in a civil case as well as a criminal case. But there is one tremendous difference between whether you assert your right to remain silent in a criminal case versus when you assert that right in a civil case. The difference is the following, a very important difference. In a criminal case, we know that there is a specific jury instruction where the judge will tell the jury that if the defendant decides to assert his Fifth Amendment rights, then you cannot infer anything from his silence. So there's a specific instruction telling the jury you cannot consider his silence anything. You have to ignore it. However, in a civil case, there could be an adverse inference that could be argued for when a defendant in a civil case remains silent. Okay, so now we're going to see the problem here. Okay, Karen Reed now is in a civil lawsuit. Let's say this civil lawsuit goes forward and they have her deposition. Now, I'm going to tell you something that was very sneaky that the plaintiffs did in this case. The O'Keefe family's attorneys, he did something a little bit sneaky. And what did he do? He did this on purpose, most likely. He scheduled already the deposition of Karen Reed. He scheduled the deposition of Karen Reed already to occur in December. Now, he knows very good and well that her criminal case is scheduled for January. Now, generally speaking, when you have a case that is filed, a civil case, discovery can be many months. And sometimes it can take years. So if you have a case like this, he doesn't have to schedule it for December. In fact, we're going to see that discovery actually extends much later than January of next year when the criminal case is supposed to occur. But he specifically is scheduling it before the criminal case. A lot of times, actually, the deposition of the plaintiff does not occur for a number of months. Okay, so we're still a few months before, we're in October, so maybe you can say, yeah, this is just a regular time. We always schedule it, 2-3 months after we file the lawsuit. That could be his argument, but I think there's a little bit more going on. Now, let's think about it. If Karen Reed in her deposition says she asserts her Fifth Amendment right, well, now the plaintiff is going to be able to argue to the jury that the reason why she was staying quiet is because she's guilty. and you are absolutely allowed to argue that in a civil case. So here's the problem. If Karen Read asserts her Fifth Amendment rights, her civil case would really, really be much harder on her, even without the experts. Still, when the defendant is not willing to say that she didn't do any of this, well, then it's going to be very adverse for her. But if she does choose to testify in her deposition, well, then she's going to be spilling the beans. And it could be that she's going to be saying something that could be incriminating and that the state can then use in her criminal case. So that's the conundrum that we find ourselves in. So what are we going to do with this Fifth Amendment privilege and this Fifth Amendment right that Karen Read has? Well, this is why Karen Read's attorneys are asking for a stay. Let's just stay the proceedings. And if she gets acquitted on the criminal case, then she'll be more than happy to talk openly in her deposition. She won't assert any Fifth Amendment right? So that's exactly what's going on here. All right. Given the discretionary nature of the court's role in ruling on a motion to stay, the decision to grant a stay ultimately requires and must rest upon a particularized inquiry into the circumstances of and the competing interests in the case. So this is quoting this very important case called So. And what does the court have to decide when they're deciding whether to grant a motion to stay or not? Well, they say that they have to weigh the circumstances and the competing interests in the case. Okay, so this inquiry involves a balance of the prejudice to the other parties against the harm to Ms. Read, should she be compelled to choose between defending the civil action and protecting herself from criminal prosecution. And then they cite here 5 different factors which need to be considered. So this is what some of the competing interests include when the court has to decide whether to grant a motion to stay. Number 1, the interests of non-parties. Number 2, the public interest. Number 3, overlap of the issues, which is obviously very important in this case. Number 4, procedural status of the criminal case. And number 5, interests of judicial economy. And they quote all of these cases, which stand for that these factors are the factors that the court has to consider when deciding whether to stay the case or not. And then they attach relevant Superior Court decisions are attached as Exhibit A. And then what they do is they go through the different factors and argue that Karen Read qualifies for these factors, and therefore the court should grant the stay. So number 1, there will be no prejudice to the plaintiffs nor the co-defendants should this brief stay be granted. What are we asking for? We're just asking for a stay of a couple of months. We're not asking for a stay of years, just for a couple of months. So there's no prejudice by waiting a couple of months. Look how long they waited already. So to wait another few months, give me a break. That's not a real prejudice to the plaintiffs in this case or the co-defendants. To the contrary, Ms. Read's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should this civil litigation proceed while her criminal trial takes place. The only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. That inconvenience does not outweigh the importance and interest of protecting a defendant's constitutional rights. And that is exactly what Green versus Cosby says, which is actually a federal district court cases. So this is in the district, and this is in the federal system, where they quoted this case as standing that a small inconvenience obviously does not outweigh the importance and interest in protecting the constitutional right of a Fifth Amendment, right? Okay. Moreover, the court's tracking order, like their scheduling order, allows for discovery up to and including August 17th, 2026. Do you see? They can have discovery up to August 2026. So her deposition can be scheduled anytime from now until then. So give me a break that you want her deposition specifically to occur right now. And sets forth a final disposition date of August 26, 2027, which means that's when the court has to be completely done with the case. The parties will have ample time to fully discover the facts concerning the allegations and defenses raised in this civil matter upon conclusion of the criminal trial, presently scheduled for January 27th, 2025. On the other hand, without a stay, Ms. Read will be forced to decide between exposing herself to a procedural default or waiving her Fifth Amendment rights. Ms. Read is not merely under criminal investigation. She has been indicted, mistried, and now awaits a second trial. The basic filing of responsive pleading to the complaint alone could compromise Ms. Read's defense against criminal prosecution. So like I said, Karen Read did not file in answer to the complaint. And one of the reasons that they're saying is that the reason why we did not file an answer on behalf of Ms. Reed is because that alone could compromise her defense against criminal prosecution. Well, what did you admit? What did you deny? So that already can compromise her defense. Okay, the potential burden and harm to Ms. Reed significantly outweighs the inconvenience to the other parties of a time delay. Thus, on balance, these factors favor a stay of the civil case. So if you weigh the prejudice to Karen Reed over the prejudice to the O'Keefe family by having a stay of a few months, give me a break. It doesn't really affect the O'Keefe family so much, and it really will significantly affect Karen Reed. All right, so then moving on. Public interest and the interests of non-party witnesses favor a stay. The public and non-party interests surrounding this case also weigh in favor of a stay. There is a significant public interest in providing criminal defendants with a fair trial and protecting their constitutional rights. While the public interest is also served by providing plaintiffs and defendants an efficient forum to resolve civil matters, right? We do want an efficient forum to resolve civil matters, right? Just because someone is also being charged criminally, so what? I still have a right to get my money damages. This civil action can still be fairly litigated within the time frame set forth in the attached tracking order. Like we said, discovery is set to expire only in August 2027. Public interest therefore favors a stay of the civil case. Non-party witnesses will similarly benefit from a stay, because that's also one of them. The non-party interest. Is there any non-party interest that would favor a stay? And they're saying yes. It is anticipated that many witnesses will testify at the upcoming trial. The same witness's testimony may also be relevant to the parties' arguments and defenses in the civil litigation. So we're going to have the same witnesses, right? Non-party witnesses are going to be the same witnesses in both cases, in the criminal case and in the civil case. Now, if the civil litigation proceeds and overlaps with the criminal trial, these witnesses can conceivably be subjected to testifying on the witness stand while simultaneously being called for deposition in civil discovery. This would place an unfair burden on both the witnesses and the parties in both the civil and criminal litigation. So the scheduling is going to be a little bit crazy if we're going to try to slam this all in now. So thus, this factor also favors a stay of the civil case. Let's continue. The overlap with the criminal case and procedural status of both cases further warrants a stay of the civil proceedings. The allegations and issues in the criminal case directly overlap with the issues in the civil case. This is also an important part that's brought out in the case law, is that do the issues and the allegations in the criminal case overlap with the civil case? And here, in this case, they absolutely do. Again, the ultimate issue here is, in both cases, was did Karen Reed hit John O'Keefe with that car or not? If you answer that question in the criminal case and the civil case, then you're going to get your answer to that, whether she wins or not. The decedent witnesses and evidence are the same in both cases. Ms. Reed's second criminal trial is scheduled to begin on January 27, 2025. A trial date has been assigned, and the Norfolk Superior Court will reach the criminal trial years in advance of the trial of this civil action. Okay, the tracking order for the civil action provides the parties within 2 years' time for discovery and 3 years' time for a final disposition, as we mentioned above. Even with a stay, the parties will still be on track to complete discovery within the current deadlines, meaning we have so much time to do discovery that if we just give a few months of a stay right now, it's not going to change anything. We're still going to be able to conduct and complete all of the discovery. Thus, the overlapping issues and procedural status of the two cases also favors a stay. Okay, let's continue with the next and the final factor, and that is that this civil action should be stayed in the interest of judicial economy. Ms. Reed's proposed stay serves the interest of judicial economy. This stay will alleviate the court's burden of ruling on potential discovery motions and requests for protective orders should Ms. Reed decide to invoke her Fifth Amendment privilege. It is in the best interest of this court, the parties, non-party witnesses, and the public to allow this brief stay until Ms. Reed's criminal trial concludes. Thus, judicial economy also favors a stay of the civil case. Now, and then to conclude, okay, that's the extent of their motion. Now, what would I have liked to see in this motion done a little bit better? And I think they could have done this and they just didn't. I don't know why. Probably because they didn't ask my advice, which they always, of course, they should have. Is that what you should do is that you're right. They did have some authority. They did have some citations to authority to support their position. But what they should have done also, and this is just a tip in general for brief writing, for all you lawyers out there or law students, when you want to prove your point, you also should show an example from another case. Say, look, this is a very similar situation that happened in this specific case. And you cite the facts of that case. And then you say, and the judge ruled in that case and granted the stay. And this stay was upheld by the Court of Appeals and by the Supreme Court. And therefore, just like in that case, which mirror the facts of this case, that's why you, judge, in this case, should conclude as well and grant the stay. So that's also something that I believe they should have done, and they could have done in this case, quite frankly, and they didn't. So just a little mistake there. Nevertheless, they did do some citations to authority, and it definitely did something for them. All right, so now let's move on to the plaintiff's memorandum of law in opposition to defendant's motion to stay proceedings. So this is the O'Keefe family's attorney responding to the motion to stay. In the instant motion, civil defendant Karen Reed seeks to stay civil discovery, largely because Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should the civil litigation proceed while her criminal trial takes place. And because, and then this is directly quoting from what we just read, the privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is ongoing. Additionally, Ms. Reed claims the only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. All right, so that is direct quotes from their motion. In certain cases, we may agree. Here, however, Ms. Reed consistently and voluntarily disregards her Fifth Amendment privilege as she attempts to craft her own narrative and poison the jury pool in both the criminal and civil cases. So they're arguing, oh, is Karen Reed so concerned about her Fifth Amendment rights that she always wants to remain silent? Well, let's see if she always chose to remain silent. Karen Reed has spoken publicly in interviews that we know of with NBC's Dateline, ABC's Nightline, ABC's 2020, Vanity Fair, NBC's Today, and yet to be disclosed Netflix documentary. So she's doing anything but staying silent. In light of her open willingness to speak publicly, Ms. Reed's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self-incrimination and more about controlling the narrative to suit her interests. The court in its discretion, again, remember, this is a discretionary matter, the court in its discretion certainly should not reward her ulterior motive of self-promotion. The right not to self-incriminate does not come with the right of self-promotion. So right away, they are coming with punches. And then they quote some other very important language. And this actually, they did a good job here citing some cases which seem to go against the granting of the motion to stay. So here we go. The movement carries the heavy burden of establishing that a stay is warranted, meaning that the defendant here, Karen Reed, and her attorneys, they carry the heavy burden. This is a direct quote from this case of establishing that a stay is warranted. So generally speaking, we don't grant stays. You have to really impress the court that you have a compelling need in order to have that stay granted. It's a heavy burden. All right. It is well settled that the Fifth Amendment privilege against self-incrimination applies alike to civil and criminal cases. Testimony given in a civil deposition does not waive Fifth Amendment privilege for purposes of subsequent criminal trial. Meaning that she could waive her Fifth Amendment privilege just because she gives testimony in a deposition does not mean that she cannot waive anymore her Fifth Amendment privilege. And now this is something that's very important to know as well. The law is that, generally speaking, if you get up and waive your Fifth Amendment privilege, you get up on the stand. You say, you know what? I'm happy to testify. No problem. And then after you give some testimony, you decide, this was a really bad idea. I should not be testifying right now. And I want to stop this right now. And you know what? You say, you know what, Judge? I made a mistake. I want to assert my Fifth Amendment right now. Can you do that or not? The answer is you cannot. If you get up on the stand and you waive your Fifth Amendment right initially, you can't just in the middle of your testimony say, you know what? I'm going to now assert my Fifth Amendment right. You can't do that. So what happens if in one case you waive your Fifth Amendment privilege to talk about a specific instance? And now in another case, they want to talk about that same topic. Now you waived it in that other case. can you now be compelled to testify about whatever you were talking about in that other case? And the answer is no. Okay, it's only for the proceeding that you are currently in. So what they're trying to say here is a little bit sneaky, because I'm going to explain why in a minute. What they're trying to say here is that even if she gives a deposition in the civil case, that doesn't mean that she can't waive her right. She can't assert her right again in the criminal case. She could assert her right in the criminal case. Just because she gives testimony in the deposition in the civil case doesn't mean that she can be compelled to now testify again in the criminal case. That's not the way it works. It's two separate proceedings. So therefore, they're saying, look, you want to assert your Fifth Amendment right? No problem. You can do that in the criminal case. And then in the civil case, give us your deposition. Well, it's really not that simple, because they can still use what she says in that deposition. That they still could do. They just can't ask her to continue to talk about that topic. But whatever she already did say in that deposition, that already could come in to her criminal case. So this is a little bit sneaky here. All right, nevertheless, let's continue. Nevertheless, there is no constitutional requirement that a civil proceeding must yield to a criminal one, even in the presence of a defendant's perceived need to assert the Fifth Amendment privilege. So there's no requirement that a civil proceeding has to be stayed because of the Fifth Amendment. The United States Constitution rarely, if ever, look at this quote. This quote is really a strong quote for the O'Keefe family. The United States Constitution rarely, if ever, requires a stay of civil proceedings pending the outcome of criminal proceedings. Wow. Rarely, if ever, requires a stay of civil proceedings. That's making the burden really, really seem very high. Rather, the decision to grant such a stay rests in the sound discretion of the presiding judge, requiring a particularized inquiry into the circumstances of and the competing interests in the case. Of course, courts must weigh any prejudice to the civil litigants which might result from granting a stay against the potential harm to the party claiming the privilege, which is already essentially quoted in the defendant's brief. The rights of the parties to the civil action are to be considered as equal. Justice is meted out in both civil and criminal litigation. The overall interest of the courts that justice be done may very well require that the compensation and remedy due to a civil plaintiff should not be delayed. So, the way that, generally speaking, the law in Massachusetts treats this type of conundrum, when you have a civil case going at the same time as a criminal case going, the general default, the default position is that you do not grant a stay for the civil case. Because, like we said here, the compensation and remedy due to a civil plaintiff should not be delayed. Justice requires that as well. So, generally speaking, we don't just stay civil cases. And like we said, it's rarely, if ever, required based on the Constitution, based on the Fifth Amendment. You have to decide. And in fact, there's some great case law that says that talks about this specific situation. Look what it says here. I got a quote here. They didn't quote this case, but they probably should have. Although the choice facing him is difficult, that does not make it unconstitutional. So even though you're right, Karen Reed would have a very, very difficult decision to what to do. Should she assert her Fifth Amendment right in the civil case or not? You're right that every single criminal defendant who's being sued civilly would have that same choice, difficult choice to make. But listen to what the court says about this. This is from, again, this case of So versus Sex Offender Registry Board. Although the choice facing him is difficult, that does not make it unconstitutional. The criminal process, like the rest of the legal system, is replete with situations requiring the making of difficult judgments as to which course to follow. So you're right. This is a difficult decision to make, but you kind of put yourself in this situation, so you got to figure out what to do. All right. So then they talk about some of the facts of this case and the procedure. And look at what they say here. This is an interesting argument that they make in their response. In an affidavit filed by the defendant's own criminal counsel in Norfolk, 8 of the deliberating jurors favored conviction on the same counts that overlap with plaintiff's claims in the civil matter. So you see how they're using the affidavit of David Yannetti saying that 8 of the deliberating jurors favored conviction, right, on count 2, right? That's according to Yannetti. They wanted to acquit on count 1 and count 3, but count 2, what did they want to do? 8 of them wanted to convict her. Well, let's think about that, what that would look like if that was a civil case. The estate has great reason to pursue civil justice against Karen Read for wrongful death, whereas 8 of 12 jurors, uninfluenced by the media circus, when tasked with resolving the facts under the higher standard of proof, beyond a reasonable doubt, believed that Read was guilty of OUI manslaughter. Our civil case only requires 5 of 6 of the jurors. So in a civil case, you don't need all the jurors. You don't need all 6 out of 6 jurors. All you need is 5 out of 6. And in a juror of 12, 8 out of the 12 wanted to convict her of OUI manslaughter. So if that would have been a civil case, again, it's hard to really say that those 8 would have been made up of the 5 that you need for the civil case, but they're arguing our civil case only requires 5 of the 6 of the jurors when tasked with resolving the facts under the lesser standard of proof, right? So 8 out of 12 thought that she should be guilty of OUI manslaughter, and that was when they believed that she was guilty beyond a reasonable doubt, which in a civil case, you don't have to prove by that much. All you have to prove is by a lesser standard of proof, more probable than not, to hold reliable. Any 2 of those criminal jurors who maintained no there could easily have been persuaded to change to a yes vote in the civil case here. Now, this is, of course, all conjecture, but, it's their argument, so let them have a good time with it. It is not difficult to imagine 2 of the no jurors being persuaded by the deliberating jury that Read's drunk driving more likely than not caused O'Keefe's wrongful death. Again, this is just argument. It doesn't, there's no strong argument here, but they're saying, since it's an easier standard of proof, so maybe would have even convinced another 2 of the jurors. Anyone familiar with the O.J. Simpson cases understands that there can be disparate outcomes with similar sets of facts, not only because the civil standard is lower, but also now the jury gets to assess the credibility of the alleged wrongdoer. Plaintiffs here are entitled to civil discovery, including the under oath testimony of defendant Read, not only to hear her version of events, but also to assess her credibility. Plaintiffs noticed Read deposition for December 5th, 2024, which I told you, see how they noticed her deposition. They already said that we're going to take your deposition December 5th, 2024. They specifically, believe me, want that before their criminal trial. That was on purpose. All right. Despite her contention that proceeding with civil discovery could compromise her defense in the criminal prosecution, Read has repeatedly emphasized that she wants to talk, right? Remember those that she got after one day of court? She was asked, do you want to take the stands? And she emphasized that she wants to talk and is eager to provide her account of the events in question. Indeed, she has addressed the matters publicly on several occasions, making her own narrative a prominent part of the public discourse. Moreover, there is no shortage of reporters, bloggers, I wonder who they're referring to here, and persons claiming that Read is actively speaking about the facts. This public engagement raises troubling questions about Read's true intentions. If Read genuinely has concerns about her statements being used against her, it seems contradictory she would continue to speak out so openly. So they're just calling out, essentially, again, the first 5 pages have been about how Karen Read is so open and has talked to all these stations and is giving interviews and really wants to talk and give her side of the story. And all of a sudden we notice up her deposition and all of a sudden she wants to assert her Fifth Amendment right. How does that equal itself? So by actively participating in public discourse and potentially profiting from media engagements, Read effectively foregoes any claim of Fifth Amendment protection. Is that true? No, of course it's not true. You know why? Because if it was true, then you think they'd have some sort of cite here to a case law that says that? Maybe there should be a case law that says, when a defendant has an appearance on a media show or talks openly in the media, then they waive their Fifth Amendment protection. Well, obviously, there's no case like that. So this is just them making up arguments out of thin air. All right, nevertheless, they're trying their best. Karen Read's choice to speak out starkly contradicts any suggestion that she is concerned with self-incrimination. Now Read comes here asking this court to allow her to have it both ways. And you'll notice in all of this, there's very, very few citations to any authority right here, which you know what that means in my book. Anyway, let's continue. Furthermore, the O'Keefe family has compelling reasons to pursue their claims with urgency as there are legitimate questions in this case regarding witness and jury manipulation. So remember that witness manipulation. Remember, there's a certain blogger, perhaps, that they were referring to before. So they're saying, well, there's legitimate questions that we got to get this case moving because there may be some witnesses that are manipulated and jury that's manipulated. Well, again, remember, there's 2 years now for discovery to occur. So another few months, is that really going to make such a big difference about whether a witness can be manipulated or jury can be manipulated? Not really. Further delay not only affects witnesses and jurors, but also the O'Keefe family, who have been dealing with the loss since January 29, 2022. So they're saying not only does this delay affect the witnesses and jurors, but the O'Keefe family. Come on, they've been dealing with this loss January 29, 2022, which of course is extremely sad here. Everybody wants justice for John O'Keefe, and the O'Keefe family are victims. The first criminal trial extended beyond a full calendar month, and the second trial is not set to begin until more than 4 months from now. Right? It's set to begin January 27th. No reason to believe that it's going to go any less than 27 or odd days than it went the first time. Furthermore, there's no assurance that additional delays, another mistrial, a lengthy appeal, or other legal complications will not arise. Like we saw in this case, right? There could be some other delays that happen. There can be some appeals, and therefore her case may get postponed, extending Reed's authority to postpone the civil proceedings. So who knows? Maybe they're going to want to postpone the civil proceedings even more. If she chooses to plead the Fifth Amendment in the civil proceedings, she may do so with consequence. As we explained already before, with consequence means that there can be an adverse inference based on her deciding to be silent. However, if she wants to speak under oath as freely as she does for the media and others, plaintiff welcomes the opportunity to obtain her testimony. By allowing the civil case to proceed, the court demonstrates a commitment to transparency and the timely resolution of such serious matters, which is crucial to maintaining public trust in the legal system. A stay would only delay justice and could foster frustration among the public who are closely watching both proceedings and expect the court to take decisive action. So everyone's watching you to see what you do here. And if you're going to grant the stay, the public's confidence in the legal process depends on seeing justice served in a prompt and effective manner. Denying the stay ensures both the civil and criminal matters are addressed on their own merits, without unnecessary postponement that can undermine public faith in court's ability to handle such high-profile and sensitive cases. So everyone's watching, you better deny the stay. That's essentially what they're asking here for. Right now, therefore, conclusion, they're asking essentially to deny their motion. So that is the motion. That is the response. What do I think is going to happen? Well, also, before I even get into that, what should the defense have done? You're right. They did cite to some strong authority, which I said, some of those citations look really strong. But what they should have done, and the same thing that the plaintiffs failed to do in this case, and then again, this goes to the brief writing. If you want to be a good brief writer, what you should do is you should cite to specific cases and show the facts of that case that you're citing to being similar to the cases that the case in front of you today, and say, look, if you're the plaintiff in that case, if you're the O'Keefe family, if you're the attorney working on that case, you find a case and says, look, the facts in this case are similar. And in that case, the judge did not grant the stay, and it was upheld in the Court of Appeals, and it was upheld in the Supreme Court. That's what they should have done. So again, a fail, at least in that part on the plaintiff side as well as the defendant side. They could have done a little bit of a stronger job in their brief writing, showing specific examples in the case law in Massachusetts, showing where whichever supports your position, a case which showed that the stay was granted or a case that shows that the stay was not granted. So again, like we said, generally speaking, it's a high burden to ask the court to stay the proceedings. In this case, since they're only asking to stay the proceedings a couple of months, I can see the judge doing that, especially given that there's 2 years for discovery to be completed in this case. And it could be the judge will say, we are going to stay the case through January 27th until the conclusion of that trial, but then no more. Meaning if there's appeals or if there's other reasons that the case gets delayed, we're not going to stay anything further than that. I can see a judge doing that. I can see a judge saying we're not going to grant the stay, and I can see a judge granting the stay with even more flexibility. But I think what could be reasonable in this case is for the judge to say, we're going to wait till the end of the criminal case if it happens on January 27th. If it doesn't happen on January 27th, we are not extending the stay any further. So we'll see what happens, but an interesting, I think, issue. And that will be it for now. Please, if you haven't yet, please subscribe, like, and we will see you next time.